Welcome everybody to the CLRNN Spotlight on Corporate Governance and Insolvency Law in Africa. My name is Bolanle Adebola. I hope you can hear and see me well. My name is Bolanle Adebola, thank you. I'm a lecturer at the School of Law at University of Reading, and I'm also a liaison officer at CLRNN. Hello, thank you. Nice to see you. I'm super excited to be hosting today's session. In the previous seminars, we've examined the reforms to Ghana and also examined the reforms to Uganda. We were pleased to be joined by Mr. Kenneth Gati and Dr. Hamisi Nsuba. I hope I pronounced your name correctly and I didn't murder it. Great. Today, we are joined by Dr. Bolanle Adebola, who is the convener of CLRNN, and she'll be presenting on reforms, insolvency reforms in Nigeria. Her presentation is titled Progressive Corporate Rescue in Emerging Economies, the Nigerian Experience. The discussant today will be Dr. Nsuba. So just a couple of ground rules just before we get into the presentation. This is a meeting, so please do ensure that you are muted so as to avoid any interruptions. The session is going to be recorded and the recording will be made available on the CLRNN's website. Is that correct, Bolanle? Yes. The presentation should last for a maximum, I believe, of 30 minutes, and there will be an opportunity to ask questions. So if I could just ask you to use the chat section to type in any questions that you have. Alternatively, after the presentation, if you'd like to speak, then please use the raise your hand function and we will come to you to ask a question. So without further ado, I hand over to Bolanle.
Thank you very much, Fola. Thanks for hosting and thanks everyone for having me. So I'm going to start with a disclaimer. This is work in progress, okay? I'm still sorting out all my thoughts. Part of the seminar series, one of the points of having the seminar series is to get feedback on some of the thoughts that one has about the papers that one is writing about. So I'm just going to start sharing my screen, and I know that everything would go slightly crazy after this, but so can you see my screen?
Yes, we can.
Okay, I should start the slideshow from the beginning. Okay, I can't see you anymore, but I believe that you can see me. Okay, so yes, so Fola has told you that I'll be talking about progressive corporate rescue in emerging economies and discuss the Nigerian experience. And I'll tell you in a couple of slides how I came about the notion of progressive corporate rescue. For those who don't know, this is a picture of Lagos Island. This is the commercial hub of Nigeria, and there you find the headquarters of several banks along the Atlantic Ocean. So today my talk would look at I would start by looking at the Companies and Allied Matters Act, which is the Corporate Law Companies Act in Nigeria. We call it CAMA for short, and so I'll just carry on calling it CAMA. I will talk you through the history of CAMA 1990, which was the first CAMA, and then we'll look at CAMA 1990 in context, which would help us understand some of the foundational principles that the founders were working towards, and then we'll look at how that had been applied in the court, and then we'll look at the CAMA 2020 changes. Very many people here must be familiar with the new laws or procedures that have been introduced, because we've had, over the past 2 seminars now, heard other countries talk about exactly the same or very similar types of procedures. That's the CVA, administration, and then some changes were also introduced additionally to enable or facilitate the achievement of corporate rescue. So I'll talk briefly about access to finance during the rescue and talk about ensuring that essential supplies are kept ongoing, and then talk about some of the changes that were introduced into the arrangement and compromise procedure. And then I would ask the question, or try to start to answer the question, whether CAMA 2020 can be described as progressive. So CAMA 1990, well, at this point, I would just say there are several blogs that have been written on the history of CAMA. I've written some, other people have written some, and you'd find them on the CLRNN website if you go to our resources tab. So I'm not going to go through it all again. I'll just say that under CAMA 1990, because of the relationship between Britain or the United Kingdom and Nigeria, our company laws have been drawn from the laws that apply in England, in the United Kingdom, primarily the law as applied in England and Wales. And for that reason, going into CAMA 1990, what they tried to do at the time was to keep the structure of the law as it was, but to then deal with the concepts. And I'll get into that in a little bit. And so for that reason, you'd find that our laws and the procedures under our laws were structurally similar to what was found under the Companies Act of 1948 of England, of the United Kingdom. These days, mainly we look at the Companies Act of England and Wales, but at the time it was still, the whole. And so we had the opportunity to for arrangements, to propose arrangements, and under that you had the schemes of arrangement procedure that could be proposed either to the company, proposed by the company to its members or a class of them, or proposed by the company to its creditors or a class of them. And as many people would know, the schemes of arrangement procedure can be used to modify the rights and interests of both members and creditors. And in terms of creditors, it can be used to adjust the interests of both secured and unsecured creditors. There was also the option of going into receivership, and that would arise either you go into a court to ask for the appointment of a receiver, or if a charge had been created over the assets, as will be known to very many people of the common law background, the remedy when there has been a default for under a charge would be an application for the appointment of a receiver, or if that power has been granted contractually, then a receiver would be appointed. Now, we know that there are different types of receiver. You could have a receiver simpliciter, who was just someone who went in there to get into the assets and recover sums that could be raised, perhaps from rent. They had no management powers. Or if the charge that had been granted, or the network of charges, as you usually would have, would include a floating charge, then the charge holder could look to appoint a person who would act both as receiver and manager, and in that sense displace the directors and managers of the company, manage the affairs of the company, and repay the sums that were owed. I will return to the notion or the Nigerian notion of the receiver manager in a few slides, but that's the general idea that we had at the time. You also had the option of having your informal workouts, but as we know, that would only work if you could enable the unanimous agreement of the creditors, if you could get them all together in a room. So I said a few slides ago when I was introducing the talk that I would explain the reason why I have chosen the notion of progressive corporate rescue. Now, when the Companies and Allied Matters Act, when CAMA was in the process of enactment, and then the period leading to and shortly after the enactment of that particular instrument, that particular act, there was a sense of jubilation. There was a lot of excitement. We had the Nigerian Law Reform Commission. The Nigerian Law Reform Commission was doing a lot of work to improve the commercial laws in Nigeria. And if you've been following the series that we just completed at CLRNN in September, you would find that I've been interviewing someone called Professor Idonigi SAN. And Professor Idonigi SAN talked about law reform in Nigeria and some of the challenges of law reform in Nigeria. Part of what we discussed was the role of the Nigerian Law Reform Commission. And at the time, it was during the military era, but they had decided to reform the laws. They had put together the Nigerian Law Reform Commission. And one of the things that had been said about company law in Nigeria was that those that were responsible for the formulation of CAMA, that they had come up with the notion of progressive company law reform and development. Now, Professor Akpoki, who was a leading scholar on company law in Nigeria, said that we hadn't seen such law reform, that type of law reform in Nigeria before. And he had said that what had been done during the process that led to CAMA was that they had the reformers, the committee who was reforming the law, had examined common law jurisdictions, several common law jurisdictions, New Zealand, Canada, England, and non-common law jurisdictions, to understand how their own company law was structured, the types of ideas that they had, the types of concepts that they had. And the goal was to extract principles that would best suit Nigeria. Because until 1990, what Nigeria had done simply was to copy and paste what had been done in England. So up till the law before the 1990 Act was the 1968 decree, and all that was just a copy and paste of whatever had been going on in England. But in 1990, they spent 2 years going through, trawling through company law. And some of the changes that were made, for example, was the fact that as at 1990, as you would know, England had not codified directors' duties. In Nigeria, we codified directors' duties. England will not codify directors' duties until 2006. But as at 1990, Nigeria had codified directors' duties. And while codifying directors' duties, they had decided how rules, the types of duties that they wanted directors to have. They had looked at the common law as it applied at the time and decided what changes they would introduce into Nigeria. And so often when people come into Nigeria and analyze Nigerian law, I always pull them up to say, well, why do you come into Nigeria and read Nigerian law as if you were reading English law? Because the problem is even the Nigerians themselves didn't understand the history or the context within which CAMA had been created. And in insolvency law, it's been really interesting because I've already said, we had receivership, we had schemes of arrangement, which again, were structures or constructions that we had brought in from England into Nigeria. But when creating our own notion of receivership, we had made some changes to the concept of receivership. Thus, when analyzing the Nigerian receivership, I've always pointed out to people that the Nigerian receiver manager is not the same as the equivalent in England and Wales, who would have been your administrative receiver at the time when the administrative receivership still applied. Now, who was the administrative receiver? The administrative receiver was a receiver and manager, a receiver that had management powers that extended to the whole or substantially the whole of the company, of the defaulting company. Now, although the receiver manager or the administrative receiver's powers extended to the whole of the company, the administrative receiver upon appointment was responsible only to the person that appointed them. And so when they, I see a question in the, okay. When they were appointed, their loyalty was to the person that appointed them. This usually was a bank. And so the receiver manager only had a duty of, to exercise good faith. They could come into the business, sell at any time. It didn't matter if they could wait one more month or wait a little while managing the business and maximize the value in the assets on behalf of all of the stakeholders in the company. Their responsibility was solely to the appointer. But here is an excerpt of CAMA 1990 and section 390, which is now section 553 in the CAMA 2020. It says that such a manager, that is your receiver and manager, shall act at all times in what he believes to be the best interest of the company as a whole, so as to preserve its assets, further its business, and promote the purposes for which it was formed, and in such a manner as a faithful, diligent, careful, and ordinarily skillful manager would act in the circumstances. In considering whether a particular transaction or course of action is in the best interest of the company as a whole, that manager may have regard to the interests of the employees as well as the members of the company, and when appointed by or as a representative of a special class of members or creditors, may give special but not exclusive consideration to the interests of that class. Now, this is the law. This is a codification of our law as at 1990. This does not match up against the administrative receiver that you had in England and Wales, because the administrative receiver's responsibilities were solely to the person that appointed them. And it is for that reason that I would say that as far back as 1990, the Nigerian notion of corporate rescue was quite different, even through receivership, from that of England and Wales. And that's because the people who created CAMA 1990 had averted their minds to the challenges that receivership brought into the company for the other stakeholders of the company. And the creators of CAMA 1990 wanted to ensure that the receiver acted in the best interest of all of the stakeholders of the company. Now, was that how receivership, the receiver manager, practiced their responsibilities in Nigeria at the time? The simple answer is no. Often, when the receiver manager was appointed, they came into the company and acted like the English administrative receiver. They came into the company and were solely interested in acting on behalf of their appointer, even though that went against the law. Now, it was not the case that everyone didn't understand what the law was. And in fact, all the way up to the Supreme Court, in the case of the West African Breweries versus Savannah Ventures Limited case, where a receiver manager had been appointed, and when the receiver manager came, they were only interested in getting into the company and getting at the assets of the company. And the company had then gone to court. And what Katina Alu JSC said was that the receiver, that is the receiver manager, had abandoned his commission to manage the company, because there had been the opportunity to manage the company and to pay back the amount that was owed and to allow the company be returned to the hands of the owners of that business. But that was not what the manager had done in that case. And so we find that there is a disconnect between the concept of receivership that we had in Nigeria and our historical colonial link to England. There was also a disconnect between what the law said and how the law was practiced in Nigeria. Now let's bring in CAMA 2020. So CAMA 2020 was supposed to reform CAMA 1990 and bring Nigeria up to the modern age and introduce concepts that were practiced in leading insolvency jurisdictions across the world. And again, as with many countries across Africa, I think Damilola wrote a fantastic paper on the influences that have led to company insolvency law reform across Africa. And you find that the combination of the influences of INSOL and the World Bank, we must all have read recently about the challenges of the World Bank's doing business report and how that can be manipulated. But that's a conversation for another day. But we find that these reports influenced the changes that were introduced across Africa. And again, if I could refer you back to the conversation that I had with Professor Idonigie, which I've said you can find on the CLRNN website, he said that what the process that led to CAMA 2020 actually started in the 8th Assembly, the 8th National Assembly in Nigeria, where he had been commissioned to examine the Nigerian business framework and how to improve the Nigerian score on the doing business rankings. And so one of the things that had been suggested, in addition to all of the recommendations that were made on the Companies Act, was to improve the insolvency portions and to introduce the notion of corporate rescue, as though Nigeria didn't have a notion of corporate rescue before. But all that had been ignored and set aside. And so what we have under CAMA 2020 is we introduced the CVA procedure, that is the company voluntary arrangement procedure. I'll talk about very briefly. The schemes of arrangement procedure was retained but modified. Receivership has been modified, unlike in England and Wales, where that has been largely restricted. The notion of administration was introduced, and then we also still have the option of the out-of-court procedures. Now, for those who may not be familiar with the CVA procedure is essentially, when it was introduced in England and Wales, was just a streamlined version of the schemes of arrangement. It's simply the opportunity for the directors of a company to propose a deal to the creditors of their company. Unlike the schemes of arrangement, in the CVA, the directors are proposing the deal to the unsecured creditors of the company, who would vote as a class. The back and forth that you would have in the schemes of arrangement, going to the court for various orders, you don't have that in the CVA procedure. You have the proposal, which will be sent with a notice to a putative nominee. The nominee is an insolvency practitioner. Now, in Nigeria, we introduced the regulation of insolvency practitioners, and so the person would have to qualify to act as an insolvency practitioner. If this person consents to act, all of the required documents, they would produce a report on the proposal, and all of the required documents would be filed with the CAC, the Corporate Affairs Commission, and then a notice of the meeting would be sent, and the meetings would be called. You could also have a CVA when the company is in administration or when the company is in liquidation. And that is because the liquidator may decide that actually, if you could strike a deal, then it might be the case that the company can actually be allowed to return to run. And the administrator might use, if the administrator wants to rescue the company as a going concern, might propose a CVA to compromise the debts of the unsecured creditors of the company. Now, as I've said, you would call a meeting. And so you would usually have a meeting of creditors and a meeting of members. The meeting of creditors would come first, and it is the result of the meeting of creditors that is more important. Now, if members are unhappy with the outcome, then they could go to court to challenge the outcome of the meeting of creditors and ask the court to substitute it with that of the members. But of course, the court will not take that decision lightly, because usually at that time, it is the money of the creditors that is on the table. And so it is not easy to exchange the outcomes of the meeting. But there's also a 28-day period within which any of a listed number of people, creditors, members, liquidator, and the like can challenge the outcome of the creditors' meeting, either on the grounds that the proposal was unfairly prejudicial or there was some material irregularity. An example of a material irregularity might be that someone didn't get the notice. And so it's important to comply with the rules as to notices. But interestingly, one of the challenges that we have under CAMA 2020 has been the fact that there have been no insolvency rules that cater to the CVA procedure, or, as I will talk about again, the administration procedure. The challenge with that, therefore, is that we don't know what the majority would be to pass a CVA. Therefore, as it stands right now, you cannot actually put a CVA across because we don't know what the majority would be. We also have the notion of administration that has been introduced, and there are different routes into administration. You could have the out-of-court route, which could be commenced by the directors who pass a resolution, a majority of them, or the company that passes a resolution in meeting, or if you have a qualifying floating charge holder. Now, this qualifying floating charge holder is the charge holder that holds a network of charges, or including a floating charge that extends to the whole or substantially the whole of the company's assets. This would have been the person with the power to perhaps appoint a receiver manager over the whole of the company's assets under receivership. You could also have the in-court route. Now, I'm just going to pause here and say that if you look at CAMA 2020, I would say that I'm terribly embarrassed at CAMA 2020, because if you read the provisions of CAMA 2020, you would find that all of the provisions, the cross-referencing, is done so poorly that it is difficult without some judicial gymnastics or judicial facilitation. You can't actually have any of these procedures come into effect, because where, for example, you should say that section 452 is what enables you to appoint a receiver by, an administrator by a qualifying floating charge holder. The section that is supposed to give effect to that appointment chooses section 450 instead of section 452, and that cross-referencing is done across board. Therefore, what we have is actually a jumbled mess, if the country wants to be honest about it. There is the opportunity to appoint a receiver in court. You could, similar to appoint an administrator, rather, similar to what you find in many countries that have administration. Anyone can go. If you have a shady or a shaky charge, the charge holder can also go into the court. The Nigerian version says that if you're going to have cross-border elements, then you could appoint one, you could go into the court to ask for an administration order. Interestingly, it also says that a qualifying floating charge holder can go to the court ex parte to have an administration order. The reason why that has been introduced is not clear. One of the challenges we have is that there is no report that explains the changes that have been made under CAMA 2020, unlike what we had under CAMA 1990. Like with administrations across the world, we have the opportunity or the effect of commencing administration is the moratorium. Again, I would recommend that you read the blog that has been written on the challenges of the moratorium in Nigeria, because again, our interim moratorium picked the wrong provisions. And if we want to follow the letter of the law, it means that our interim moratorium can actually never take effect because the correct provisions of the law or the wrong provisions of the law have been picked. But if we go with the principle, then we have the interim moratorium, which starts when the notice of intention or the application has been filed, and you can still make an application to the court to petition for the winding up of the company, but you cannot get an order. The holder of a qualifying floating charge can still appoint a receiver manager, and if a receiver manager is in office, that receiver manager can still act. When the full moratorium takes effect in principle, then all these other additional allowances would be dialed back and everyone would be stayed. Now, the administrator, like the nominee under the CVA, must be qualified to act as an insolvency practitioner, and they must perform their functions in the interest of the creditors as a whole. Now, remember that the Nigerian receiver and manager was to act in the interest of the company as a whole, not simply even the creditors as a whole, but the company as a whole. And so when I start talking about progressiveness, the question would be, is it progress? Can we describe what we have done as progress? But I will get to that in a few slides down the line. The administrator is also to set out proposals within 30 days of appointment. These proposals are to be voted upon, but unfortunately, because we don't have the rules, we don't know the majority to pass these proposals. Creditors may challenge the administrator's actions in court. This would be one of the things that our own receivership did not give us at the time. So this would be an improvement. Now, I would run quickly to the arrangement and compromise procedure. Arrangement and compromise procedure well, I think I've mixed up one of these slides. They've tweaked the arrangement and compromise procedure and introduced one procedure specifically to compromise the debt of creditors. And so it says that the applicant can make a summary application to the court to convene a meeting, and it includes the majority that would pass it. So majority in number representing 3/4 in value of the required class. But it says that the classes would be put together according to their interests. Actually, what the law should have been is according to your rights. You are classified according to rights, not according to interests. Again, the reasons why rights has been substituted with interest isn't really clear. When the plan has been passed, it would be referred to the Securities and Exchange Commission that would investigate the fairness and report back to the court. And then the court may sanction the report. A certified true copy has to be registered for that proposal to come into effect. Now, one of the new changes that has been introduced is the moratorium. It says that during the process of the compromise and arrangement, that no creditor may present a winding up petition or undertake any enforcement action against the company for 6 months, so long as the documents have been filed at the court. And it lists what these documents are. These are documents that pertain to the proposal. And then a step down the line, it says that a secured creditor may, by application filed within 30 days of notice of the arrangement or compromise, discharge the moratorium. It doesn't say, for example, whether that discharge is only pertaining to that creditor or discharge the entirety of the moratorium. And they can discharge it if the assets of the company to be enforced by the creditor does not form part of the pool of assets considered under the arrangement, or if the asset is a perishable good, or if the secured creditor has enforced their security before they knew that the arrangement or compromise was being proposed, or if the company consents in writing. And these are really broad powers that have been given, or broad rights that have been given to the secured creditors to take themselves out. As one of my colleagues has argued, that one of the things that you expect banks to do then is to ask the company to sign the consent at the time when they present the company with the loan documents, so that they would always be able to step out of these moratorium. There's also questions that can be asked about the interest of other people and how this is balanced in the consideration of the moratorium, but time does not allow me to go into all of this. Fola, I might run over by 5 minutes, just keeping an eye on the clock.
Absolutely fine.
Okay, and so we know now that there are different routes for the debtor or the creditors or the company itself to facilitate the rescue. Now, of course, we know that the company that is in trouble would need money. And so one of the things that has been introduced, which we didn't have before, was the notion of post-commencement financing. This is applicable only in administration. It's not applicable in either arrangements and compromise or your CVA. Now, it says that the administrator may enter into a contract for post-commencement financing, and that post-commencement financing shall be charged on or payable out of the property of the company, which the administrator, at the end of the procedure, had custody or control over immediately before the end or the termination of the administration. And it will be payable in priority to any charge arising under subsection 2. Subsection 2 then tells us payable in priority to any security to which section 510 applies, and section 510 tells us, it talks about the administrator's proposals will not affect the right of a secured creditor. Now, it doesn't distinguish between holders of a fixed charge or holders of a floating charge. This then can be interpreted to mean that you can have super priority above both the fixed and the floating charge. All this without the need to, go to the court or to ask the creditors or any form of accountability over the actions that are going to be taken. This certainly sets Nigeria apart from, for example, the UK, where they don't have this power, or the US, where you have to go into a court in order to have a priming lien. And so again, this is really interesting. And the chances that anyone would permit any bank or fixed charge holder or even floating charge holder would permit an administrator to be appointed is fast diminishing. There's also the opportunity for the insolvency practitioners to ensure that essential supplies are kept ongoing. And the law says that the supplier can make it a condition of supply that the office holder will personally guarantee the new debt, but cannot make it a condition that the former debt would be paid or must be guaranteed before the new supplies can be made. The effective date is the date at which the company goes into either a CVA or into an administration or liquidation, amongst other things, depending on the type of procedure that has been entered into. So I'm going to ask two questions quickly. Can we say that the law is progressive? And what is the nature of progress, essentially, that has been made? And I'm just going to stop sharing in order to answer this question. If I can find where stop sharing is. Okay, I can see myself, so that's easier for me. So is the law progressive? It depends on how we define progress. Progress can be said to be this notion of motion, making advancements in the law, development in the law, improvement or development in the law. We could also look at the notion of progressiveness from the political lens or the political philosophy lens. And there you'd find that the ideas that are being proposed there are looking to represent the interests of ordinary people by introducing notions of fairness and justice. And if we look within corporate law, the notion of progressive company law looks to notions such as CSR, and so that dials back to the Dodd versus Bell argument and the notion of the stakeholder approach to corporate law. We've also had notions of progressivism in corporate insolvency law. And for that, we could look to theorists like Donald Koropkin, who talked about communitarianism. And that brings the notion of stakeholderism into the realm of insolvency law and talks about rescuing companies in the interest of the company, that is its members, its secured and unsecured creditors, as well as the community. Now, this is an ongoing conversation or argument, even in England or in the US, across the world, as to how to position corporate rescue. And it's interesting for me to find that this is an argument that we've actually been having in Nigeria as far back as 1990. And so I will not say that we have succeeded in answering that question. Yes, we have brought in more stakeholders into the conversation, but we've always had those stakeholders in the conversation. It is simply that it was not practiced the way that it ought to have been practiced. Have we made forward motion? Have we made any advancements? I would say that the advancements we've made have been very limited if I look at where we started from. Where we started from, the understanding was that we see what's going on across the world, and then we take one up on them because after all, we're Nigerians. We always do one better. But what has been done in 2020 does not match the ethos of what was done in 1990, and thus, for me, leaves a lot to be desired. And that's the end of my presentation. If I can stop sharing. Have I stopped sharing?
No, we can still see your screen.
I don't know how to stop sharing. I don't know. Maybe we just continue while I try.
Maybe we just keep looking at progressive.
Look at the bottom of your screen. There is a red button to press.
Okay, I've seen stop share.
Okay, fantastic. Okay, thank you very much for that very insightful presentation. I feel like there's some harsh words for Nigeria there, you know, the 2020 karma. I would like to invite questions, but I'm also just going to hand over to Hamisi as the discussant. So yes, I hand over to you.
Thank you very much, Bolanle. Thank you everyone for attending. It's such an honor again to be able to present my ideas on Bolanle's paper, and it's such, although she says it's still a work in progress, it is a good paper which touches several aspects on corporate rescue and the evolution made, the journey made to revamp or to try to bring Nigerian corporate rescue law or company law in tandem with other developing or developed jurisdictions. I don't have much really to discuss apart from trying to build on some of the arguments made by Bolanle. And one of the two questions that she touched upon, should corporate rescue be progressive? For me, that is a key aspect. If you're looking at Africa and emerging economies or developing jurisdictions, that is a big question. We have our lawmakers, we have practitioners who all seek to improve the law because it is part of day-to-day living. When you look at the economic space, when you look at the business structures, when you look at international trends, the way we collaborate, the way we work, trading in commerce, we need to have law that is up to date, that is functional, that is fit for purpose. But having a breakdown of all of those aspirations, we still have to answer a question. Should corporate rescue be progressive? To me, my answer is yes. But there are key factors that have to be present, key factors that we have to satisfy or to interrogate to ensure that they are in place. For example, fairness, collectivity, inclusivity. If we say the Nigerian corporate rescue model is progressing, does it touch upon fairness? Is it fair? Does it treat extant stakeholders equally? Is there collectivity in terms of, is there inclusivity as well? Are all stakeholders included? How about their interests? Does the law provide for consideration of greater interests as a whole? Or is the law protecting a certain category of parties or stakeholders with interest in the company? And looking at these factors, fairness, collectivity, inclusivity, we also have to look at other academics and policies and law. We have the law, we have rules, we have policies as well. Now, another key issue I picked out from the Nigerian latest corporate rescue law was the CAMA 2020 didn't have the rules to accompany it. So we have legislation, CAMA 2020, but then we don't have complementing rules like insolvency rules. And this, for me, this is a minus. This is something that should have been thought of. This is something should have been put forward by the people that made the law. The problem is, when you look at our legislators in parliament, some of them are political appointments. Some of them are voted into parliament and they don't have good legal knowledge or background, and they pass through bills and they debate and then they pass legislation. And then you have the judges who have the task of interpreting the law and applying to the law when they are faced with issues before them to have legal solutions. But and then you have practitioners who will look at the law, try to solve issues, and then go to court and then argue these legal problems. Then when you don't have rules to accompany certain acts of parliament or legislation, that becomes a challenge. If I go back to Uganda, when we had the Insolvency Act 2012, 2011, we had the insolvency rules, 2012. Those rules would supplement the act, but then Nigerian legislators didn't make that available. And I think this is one of the key aspects that Bolanle can build on and maybe put it before the policymakers, and maybe it could be some part of the quest for reform. Also, Bola talks about concepts like communitarianism, and I love theory, I love insolvency theory, and I've written on insolvency theory and I've debated on those theories. And the best way we can analyze whether the law is progressing is looking at theoretical perspectives. And then we look at policy perspectives as well. If we look at the way academics like Karen Gross talking about community interest, taking community interest into consideration or into account in bankruptcy, then you have Elizabeth Warren talking about bankruptcy policy, and then bankruptcy policy in an imperfect world. And then you have Korobukin talking about rehabilitating values. All of these theoretical perspectives point to key factors like fairness, inclusion, and these are the things that have to be present in legislation if we are to assess whether indeed law is progressing. And without such perspectives, it becomes a challenge. I understand CAMA is in its early stages and there is a lot to be seen. How policymakers, how judges will approach the provisions in legislation, but already we have challenges being echoed from different actors. Earlier in the week on Monday, I was interviewing a PhD student who wanted to join Middlesex to write a PhD by public works. And some of the publication, he wrote a good piece talking about CAMA and receivership in terms of private security, private property security in Nigeria. And the concern was what the legislators did in 2020, in enacting the CAMA 2020, they disregarded the crust of the law in CAMA 1990. They wanted to move with modernity, forgetting the very basis upon which CAMA 1990 was enacted. And he was saying that receivership is confused in CAMA 2020 from the receivership in CAMA 1990. He says that when you look at the composition of business structures in Nigeria, MSMEs are the most. And when you have receivership as a tool, which gives more to the debenture holders than these small businesses, it becomes a challenge. So there are already concerns coming out and attacking CAMA 2020. It's in its early years, but for me, whether the question on whether corporate rescue in Nigeria has progressed, I would say yes, but to a certain extent. Yes, there are certain changes like the moratorium giving more protection, but again, there is room for improvement. There is a need to see how practitioners and the judges will handle the provisions in the new legislation to give legal solutions whenever there are questions presented before them. And I think I'll stop there because I don't want to go too deeper into theoretical arguments, but yes, we have to watch the space and see how the law is being implemented and how Nigerian economy can benefit from such legislative changes. Thank you very much. Back to you, Fola.
Oh, back to me so soon. I was really interested in these theoretical discussions. So I'd like to invite questions from anybody in the audience. I might just abuse chair's privilege and just ask the first one. So Bolanle, with the challenges that you've noted with CAMA 2020, because it seems that you're not a fan at all, what would you say is the next step forward? You know, what are some of the things that possibly we need to now start thinking of? And then I'll come to you.
Yeah, well, I would say that, well, I'm entirely in agreement with Hamisi. I will put it out there to say that actually, I have not said that I'm a progressive. My politics tends to be different. I haven't said that I'm a progressive, but it's a question that I am asking, and it's at the heart of the project that I'm working on. Either, yes, I believe in fairness, and yes, I believe in justice, and Hamisi and I have talked about working and what's that word?
interpretive approach to law.
Yes, that is the word. And the role, when you're asking a few people to determine what the outcomes should be in a way that binds everybody else. So it's still a question I'm asking. I will not say I believe in bringing the community in, but definitely in making the system a lot fairer. But when we go specifically to CAMA 2020, well, I have joined as many, I think, opportunities to help as are available in Nigeria. Recently, as a member of I was invited to join the Nigerian Bar Association section on business law on corporate insolvency law, that committee. And we wrote to the Corporate Affairs Commission to state that this lack of rules is a problem. And what we were told was that the Corporate Affairs Commission is looking into it and they're developing a body of rules. I was not asked to sit on that. And I'm interested to hear what the outcomes or to see what the outcomes would be. It would be unfortunate if they make a harsh job of that as well. But quite apart from those rules is the fact that the law itself, the substantive law, the CAMA itself, is so riddled with cross-referencing errors. Not only cross-referencing, conceptual errors. They didn't realize, for example, the differences between the receiver manager and the receiver of part. And that meant that the things that, because Nigeria didn't have administrative receivership, and so there are certain provisions that actually pertained to the administrative receiver, which you then would have put the receiver manager there, that they would put a receiver of part. All these are problems that actually have to be addressed in the substantial law or the substantive law. I will keep writing, and hopefully maybe someday someone sits down to review at least the insolvency part. Chief Idigbe is on the call. He's been involved in trying to reform.
I was just going to come to him actually.
To reform insolvency law specifically. I don't know, maybe with Chief's push and the push of several other people who are powerful enough in Nigeria to make a change. Maybe some of the insolvency acts that are floating around in the National Assembly might actually come back to us for review. I'm on the National Assembly's business roundtable where we review some of these bills. If it comes, then perhaps we'll have another opportunity to discuss these matters and set them to rights. That's the best that I can do. Ken has a hand up.
You're a powerful woman, Bolanle, all these committees, okay? Remember me.
I work for free.
Kenneth, if you'd like to ask your question, please, if you'd unmute yourself.
Okay, thank you. First a comment, then my question. It was interesting to see that after managers are appointed under the CAMA 2020, they assume what is the equivalent of director's duties. I don't know whether they assume the scope of the director's duties or whether these are duties that are specifically dedicated to managers. It was interesting to see that you codified the director's duties in 1990, but I might as well share that when Professor Gawa of the LSE made recommendations to the Law Commission in England and they were not accepted, he put it into our law far back as 1960, which was subsequently passed in 63. So we have almost a 27-year jump ahead of Nigeria on the codification of director's duties. That out of the way, two questions. I see that under the CAMA, the plan to investigate the fairness of an arrangement is referred to an SEC, to your SEC, rather than a reporter appointed by the court. And you made a comment that there is a certain danger in the post-commencement financing receiving priority, like basic priority. That's the same under our 2020 legislation as well. Post-commencement financing is ranked as a Class A debt, and as such takes priority over even previously secured debts. I got the impression that you thought that was dangerous. I can't tell why that is the case. Thank you.
Thanks, Kenneth. I was going to be gracious and say that, oh yes, Nigeria was inspired by looking at the law in Ghana. And as you know, Professor Gawa was also the Dean for the Faculty of Law at the University of Lagos. In those days, they just used to move around. But you were very ungracious in the response that you made by saying that you had a 27-year jump on us, and every Nigerian on this call knows that we don't take that lying down. So no, I will not be that gracious to you anymore. In terms of the responsibilities of the manager, the receiver manager, or the administrator, well, when they are appointed, they occupy the space of the directors. And so essentially they have the powers. And that is why you would say that you can't have both directors and the administrators performing directors' functions. You can't have a diarchy in the company. So it is only powers that the administrator or the receiver manager permits the directors to exercise that can be exercised by them. The director, the manager or the administrator can appoint, remove directors, call meetings, and do a slew of other things that directors have the power to do. They effectively become the directors of the company. Now, in terms of post-commencement financing, my core reservation, and that's a paper that I'm also looking at, my core reservation with that simply is this, that you don't want to place it would have an effect on how would I call it, ex-ante funding. If the holder of the fixed charge knows that without their consent or without even a court having a look at the fairness of what is about to be done, that the administrator, if appointed at any point, can simply go elsewhere and ask for money that primes their lien. Because the reason why you give a fixed charge is because that's the highest level of protection, of proprietary protection that you have. And I believe that if the lien of such, or the security of such a creditor is to be primed, then there should at least be a layer of accountability over that, so that we know that it is utilized responsibly. That is my own challenge with it. It's going to make credit more expensive, and everyone starts moving around looking for what else to do.
Well, if I may, just a short, but would that not also mean that the objective of business continuity is avoided? Because no one else would want to lend money to a company which is insolvent or in financial distress unless they know that they move in the ranking or in the queue.
Well, these are, you see, for me, these are the conversations. So maybe we have a panel discussion one day where we have, a discussion on post-commencement financing, and then everyone brings their own perspectives, and then we can all learn one from the other. And for me, that's the point of having these seminars. But I take your point.
Thank you very much. I can see there's another hand, Ahmed. Well, there are a few people called Ahmed here, so I hope this is the correct person.
The person with the hand up.
Yes, so Mr. Ahmed, if you'd like to unmute yourself, please.
We don't know that it's Ahmed. It's just that Ahmed's name is on everyone's name.
He's not Ahmed. I've forgotten his name. He's
yes, he's come on camera. So if you'd like to unmute yourself and
sorry, everybody,
and tell us your name.
Bessie is something like that. I've just forgotten his name.
If you could please tell us your name as well, thank you.
Yeah, that's the person at Lancaster, is it?
Yeah, my name is Maxwell. I'm the research
Maxwell,
student.
isn't it?
Yes.
Maxwell,
yes.
Yeah. I'm very, let me first thank Bolanle for what she's done. I think that she's probably covered the field. I'm very interested in, one area that I'm interested in is the argument about whether CAMA 2020 is a progressive enactment. And that is the area that I would like to see if she can explore a little bit further. In terms of the cross-referencing errors, and in terms of the lack of insolvency rules for practitioners, and in terms of cross-border insolvency procedures as well, I probably will agree with you, Professor Bolanle, that the law is not progressive in that sense. However, I'd like you to look at it from this other angle, from the comparative aspect. If you compare what we have in Nigeria as in CAMA 2020, the development CAMA 2020, with what's with other. I don't want to classify them as progressive enactment, but with other corporate rescue or insolvency enactments in countries like Uganda and Kenya, Ghana, for instance, and some of our neighbors like Cameroon. What do you think? Do you still think that our law, CAMA 2020, is still not progressive? Would you describe CAMA 2020 as progressive in the sense that it is now far ahead of other the insolvency statutes from other countries with regards to stakeholders' interests?
Well, thank you. Thanks, Maxwell, for the question. Well, I would say your cross-border questions will go to Chief, who's writing a whole thesis on that. Obviously, we don't have cross-border law in Nigeria at the moment, so it's still a conflict of law issues. And Chief can always tell you about many of the experiences that they have had in dealing with these types of issues in practice. As to whether CAMA is progressive, here's, for one, the first answer I would give you is, here's the key challenge. What does it mean to be progressive? I've told you that progress, it can be a question of, oh, we made advancement, or it can be a question of it's progressive in the political or jurisprudential sense in that it is a lot more inclusive. Now, if it is a question of we made advancement, yes, we introduced new things that you would say bring us to a comparative level with others in terms of the names of the procedures that we have, and in terms of maybe some of the slight adjustments like the moratorium with administration or the moratorium with the schemes of arrangement. But in terms of the ethos of our insolvency system, I would say that we actually didn't quite make progress, because the ethos of our system was made up of two things. First, we always had a communitarian approach to insolvency law if we looked at the ethos of 1990. But secondly is the fact that we always had this idea of, you see what is going on across the world, you look at what is going on in our own world, and then you see what you can improve. In 2020, people have gone on to preventive frameworks. So to say that you introduced administration, which you had the equivalent of as at 1990, is not progress to me. I don't see what the progress is unless you think simply calling administration alone is progress. For me, I look beyond the name onto the ethos. And I say that part of the challenge we've had is that even those of us who owned the law did not interpret our law appropriately. The simple, I would always refer back to what my very first presentation ever as a PhD student. I challenged the World Bank's report. The World Bank's report described the Nigerian receivership as anomalous. And I said because the person who was in charge of the report was there, and I said, it's interesting that when Australia took administration and transformed it from an out-of-court procedure, from an in-court application procedure to both in-court and an out-of-court, or transformed into an out-of-court procedure, the UK looked at Australia and said, wow, that's progress. And then they re-imported that into the UK and said, well, now we will have both in-court and out-of-court. Why didn't they say that was anomalous? Why was it that when we said, okay, let's keep receivership, but let us make our receiver manager responsible to the entirety of the company, it was described as anomalous? So if you ask me whether we made progress, I would say if simply ticking the boxes of the names is progress, then yes, we made progress. But for me, it is extremely narrow, limited progress that we've made in terms of the ethos of what was brought into our law.
Thank you very much. Thank you very much.
Thank you very much. And the next question, Chief Idigwe. Good afternoon, sir.
Good afternoon, everybody. Well, Professor Bolanle, thank you again for this webinar. Very interesting topic. But I would just like to deal with two issues. I think one is the question whether the reforms in Nigeria have made any progress. And then the second issue I would like to deal with is the reform process itself. You know, maybe just share a little bit of my experience. Well, actually, in order to address the two questions, I will just follow my experience. And I recall that when we were involved with trying to do the law reform itself, many of the ideas were on the table. So, for instance, the American approach of trying to deal with financial distress without reference to insolvency as a basis was on the table. But the problem was that almost everybody that was on the table did not understand the American approach of, say, Chapter 11. So it was a very difficult sell. Most of them were comfortable with the UK approach. So there's that challenge in terms of trying to do any reform in Nigeria. So that's partly responsible because if perhaps and that's part of the challenge of legal transplantation. People sort of like focus on what they are familiar with, and they're not that adventurous to move a little bit too far from, you know, the area they are comfortable with. And that was exactly what happened. When we realized that we're not going to be able to sell, and if you are consulting or advising on things like that, remember that after you come out with your draft, you have to sell it. You have to sell it to those who are going to go before the National Assembly to argue it. You have to, even those in the National Assembly have to understand it. And then, of course, you know, there are a few, what I'll call pocket lawyers there, who actually, once the bill comes out, they take over the bill and they become, they claim to be the experts speaking to their colleagues. And if they don't understand it, they can't sell it. So it was a big challenge. And then another thing is that you always need a host, somebody who is, the way it works in Nigeria is, if you are not part of the bureaucracy, part of government, and they see you as an outsider. Yeah, so if you need to usually have a host. So it was very difficult trying to get a host, and eventually, you know, at times it could be like CBN as a host, and then you end up with, let's say, the secured credit transaction, so many other laws that have come through the CBN, or you may have the BPA, which is responsible for economic reform, you know, as the host, and then you have a whole host of laws like the NCC Act, the NEC Act, so many laws that reform different sectors of the economy coming out from BPA. In this particular case, so we were looking for a host. We had, let's say, as practitioners who were not part of the bureaucracy, we did have a particular bill that went to the level of stakeholder meetings with the Ministry of Trade as the host, and then all the stakeholders were there. Eventually, we found that there were certain hosts that had their own program, like you had the CSC trying to amend their own law. But I tell you, when you see many of these hosts, when they are trying to amend their law, all they are concerned about is the powers of the board, the tenure of office, and things like that, right? So, but immediately they were trying to amend their law. Again, incidentally, as you know, when the World Bank does not partner with private hosts, so their client must be a government department. So even the World Bank was looking for a host. So everybody was looking for a host. So when eventually we saw come out the CSC trying to just amend the normal amendment we're familiar with, then everybody jumped on them as a host. The NBA, World Bank, BRIPAN, and then you go through what they call in reform retrofitting. So you come out with all your beautiful ideas, and it ends up with a host, with somebody there who doesn't really understand the issues, trying to retrofit it to be consistent with the ideas that they know and understand and comfortable with. So you see in some of the reforms that I've been involved with. So for instance, when we were doing the Investment and Securities Act, and we were trying to eliminate the need to go to court as part of the process to do certain categories of mergers and acquisition to reduce costs. And we did all the provisions. So you see the provision that has done it categorized in small measure, medium measure, and large measure, right? And the procedures that will not include it. And then when it goes back to the host, they were familiar with court-ordered meeting. They put it back in another section. So, so you have those anomalies that, well, I want to be careful about the word anomaly because of the comments that Professor Bolanle made. But yeah, but that's the experience of law reform in Nigeria. It's really quite difficult. Now, having shared that experience, the question now is, so what do we do? I think that there's a tendency to think that we've made so much progress with CAMA 2020, therefore we should go and sleep. I think even the feeling that I get so far is there's certain sort of relaxation. Everybody's so happy. You know, BRIPAN is trying to enjoy its new status. It's trying to consolidate. Everybody thinks everything is okay. But BRIPAN just had a conference, and I think I spoke around the inadequacy relating to no specific addressing of insolvency of medium and small scale enterprises, and how significant that issue is, not to talk about the other issues around preventative insolvency for everybody, including the MSMEs, you know, so not to talk about the fact that we haven't even touched personal bankruptcy and how that again relates to, you know, insolvency of small enterprises. So there's still a lot of work to be done, but now there are different. When the gentleman from Lancaster who spoke about comparison spoke, he didn't include South Africa, because South Africa has more interesting, you know, law, because they try to separate between insolvency on the one part and business rescue, right? And then created a completely new profession of business rescue professional and created clear obligation to put the company into some procedure and, you know, those things that are a little bit vague under the Nigerian law, they made it a little bit clear. But again, there are lots of analysis showing that they created an albatross, right, in South Africa. But but they did actually bring in some of those concepts of Chapter 11 in their own way, right? So is it more progressive than the one in Nigeria? You know, these are difficult issues to say, but everybody does it according to their history. They said that, you know, that the corruption or whatever, or dissatisfaction with liquidators and receivers were so high that they didn't want the same set of people to run the new profession of business rescue and that profession. So they completely separated it, etc., in line with their own history. So I think ultimately, in law reform, you have to always adjust it to your own history. That's one of the things that I've learned, to the capacity of your people, to what they understand. And you have to keep pushing them, consistently. And I think that even in Nigeria today, I think we are ready for even larger reform around some of those areas that I've spoken about. And that explains again in Nigeria, because funny enough, at the hosting level, even CAC was comfortable with a cross-border adoption of the model law. But when it went into the bill at the National Assembly, they saw it as political. And they removed it from the bill at the National Assembly, that, they will recognize a foreign insolvency practitioner. And you may think that that is a stupid position, but it's not. When you work within the context of international law, if you look at the first country that actually made an effort to adopt the model law was Eritrea. Eritrea was very, very anxious at that time to, reach out, and they were doing a reform to improve their law, because their law is based on that of Ethiopia. And they were trying to do the reform at that time, trying to separate themselves from Ethiopia around 1997, just as the model law was adopted. So, and what happened? It was recommended. And in fact, if you look at many of the works that I reviewed, many academics were stating that Eritrea was the first country to adopt the model law. Guess what? It was never adopted. And when you go back and do the research, you find that it was not adopted because, although it was recommended for the amendment of their commercial code, they didn't adopt it in the country because there were sentiments in the country that, most of our people have gone abroad because of poverty here, right? And so if they owe money abroad, they are going to, if you adopt this law, it will be easy to come and enforce the insolvency here in Eritrea. And so because of that sentiment, so they saw it that there was no benefit for the country because they didn't have any assets locally, and they themselves didn't have assets abroad. So they felt they wouldn't need it. And they didn't want it to be easy to come after their own citizens in their country. And so they didn't adopt it. And that was Eritrea, in 1997, 1998. Jeez. So in terms of Nigeria, one can then begin to understand the sentiments around the UNCITRAL law. And then when you go around the world, you find that many countries didn't adopt it as well. So there's really much more there. And that's part of what I try to explore in my dissertation. Okay. Yeah, thank you.
Well, Chief is going to give us. Chief, are you presenting in February?
I think he is. Yes, we can rip him.
Okay.
Yeah, he hasn't picked his date.
No worry, we can rip him into it. I think a presentation on this would be quite insightful as well, I believe.
Yeah.
Okay.
The Bolanle will send you. She'll send you the invitation. But I for one would be quite interested, as I'm sure many people here would also be. Thank you so much for that insightful question and for those comments, Chief Adigbe. I'm just conscious of time because I'm a strong advocate for time. So I think we've come to the end of this session today. I'd like to thank Bolanle for your very insightful, very progressive presentation. I, for one, really enjoyed it. Thank you to Hamisi as a discussant for your very insightful points also, and to everybody for your questions and for your comments. So we look forward to seeing you. Is it next year, Bolanle? Am I correct?
No, we still have some before the end of the year.
Okay, so we still have
send the invite.
Okay, so the invitations will be sent. If you are interested in presenting, please do get in touch with Bolanle or Hamisi. I can put if you just put your emails into the chat box, please, quite quickly, just in case that nobody has it. I suspect that they do, but just in case. And just to say thank you to everybody for making time out to join us today. And we look forward to seeing you in the next seminar. Thank you.
Oh,
Thank you.
Bola, I just have one last thing to announce. Next month, October, so many colleagues have voiced concerns because lecturing has begun. So they've requested that we take a break for October.
Okay.
Yeah.
Okay.
So we won't have a seminar presentation in October, last Friday of October, 30th.
Okay.
But then we shall have one in November.
Okay.
Yeah. So next month, but we shall also send out an official email, but just to let everyone who's here. So many colleagues are trying to settle into the new academic year, and it's a struggle.
Okay.
Yeah.
Great.
Definitely.
All right.
All right.
Thank you.
Fantastic. Thank you to everybody. And we look forward to seeing you in November, not October. Take care. Bye.
Thank you.
Hi, Titi. Bye, Titi.
Can you stop?
Can I stay? Yes.
Okay. No.
If you pay